and welcome back to yet another episode of Legal Opinions with Clementina. I remain your favorite lawyer, Clementina E. Ukiri, Esquire. We have something very important and cogent to discuss on property transactions. Now, when a purchaser of a land sends his lawyer or her lawyer on an errand of investigation of title, what are the pillars of investigation? What is the lawyer looking for? A lawyer who is into investigation of title must have this at the back of his or her mind. What am I looking for? Am I just going to read documents and give reviews? What is the guiding point of my investigation? 1. Ensure that the seller, the vendor, the purported owner has the power, has the authority, has the right to sell the landed property. 2. Ensure that there is no inexplicable break in chain to the devolution of the property. Let's say the property is coming from a great-grandfather to a grandfather to a father, now to a son. The son wants to sell. There should not be a break. How come it came from a great-grandfather to a grandfather and to an uncle, back to a great-grandson of the grandfather? You must make sure that every break is explained by document and evidence reasonably and factually. Anything that cannot be explained is a red flag. Cardinal pillar number 2. Number 3, ensure that there is no exception, restriction, reservation to the use of the property. If they say the property is only for agricultural purpose, and then the purchaser would want to use the property for commercial purpose of building a twin tower, building a shopping mall in the future, in the next 10 years, then the restrictive covenant tied to the landed property becomes a red flag you should look out for, except your client, the purchaser, has expressly stated that I will use the place for the purpose the covenant tied to this land is meant for. Otherwise, look out for that and run away. In fact, give a legal review and opinion to your client at the point of writing your search report. 4. Ensure that the description, the addresses in your title document corresponds with the factual description of the property. Your document cannot say that the land is adjoined to family B, and then in reality, the land is actually adjoined to family C. That is a red flag. 5. Look out for encumbrances in the title. Does the title say that you can use it for your lifetime, but you cannot sell? For instance, there are some gifts in wills where the testator, the owner of the will, says that I'm giving this house to my son, party A, to use for the purpose of residing in it. And afterward, he must only pass it to his children and can never be sold. Such land, you cannot buy them as a purchaser, deviating from the purpose it was given. 6. Ensure that the necessary consent to deal in the purchase of in selling of a land has been obtained. For example, if the property is a joint property, tenancy in common, joint tenancy, you should understand that the two persons who have stakes and the ownership rights over the land must give their consent before the land can be sold. Same thing applies to a family land or a community land. Then number 7, ensure that all charges and dues are paid and receipted for. Don't go and buy land that is owing land use charge for the past 20 years, because if you do, you are going to buy the liability and then you'll be the one to pay for them. 8. Raise requisitions when necessary. Requisitions are questions, clarifying questions. Ask questions, ask more questions and more questions. 9. Where the purchaser is satisfied with the reply from the requisition, then the purchaser solicitor must and should prepare the deed of assignment, the instruments of transfer of title. Remember, the party who will lose more in a transaction should be the one to prepare the document of transaction, the document of transfer, the deed of assignment. We'll call it a break from here. I'm happy you listened up to this point. For now, bye.